The Practical Memo. Today's lecture is all about the messy process of going from the step of analyzing the common law to creating a big picture structure for your memo. In particular, we'll go over how to analyze the issue of functional reasonableness, or functional overbreadth, in the 5 cases that we're using for this memo assignment. So remember our first lecture? Good legal writing helps legal actors make decisions. But to understand what that really means, let's look at our case study. What legal decisions do people need to make? On the client side, for co-works, these are the questions the client needs to answer. And then what about our partner that we're writing this memo for, Jamie Rodriguez? That is the ultimate decision she needs to make. And in order to do that, what she needs from you is something that we call the lay of the land, like this topographical map. What we mean by that in English is that we want a bird's eye view or a map view of the big picture. The hard part, of course, is that sometimes that legal landscape is unclear. And in U.S. common law practice, often it's unclear. So the answer may be, it depends, or probably. Our role then in being lawyers for co-works is to be clear about what may be unclear, the law. Our job is not to overstate, but to be accurate. So how do we do this? How do we analyze this before we even begin writing that memo? There are 2 parts. Obviously, the memo assignment asks you to focus on the first prong, which is about being narrowly drawn to protect the employer's legitimate business interest. I think this prong is actually quite easily satisfied based on the case law. The next question is much more involved, and this is where I would like you to focus your memo. Is the non-compete functionally reasonable, or, on the other hand, another way of saying it is it overbroad? Now, of course, these inquiries are related, but as I said, the functional inquiry ends up being much more crucial. So then how do we analyze? We need to look carefully at the non-compete itself and the language of that contract. So it's a lot of text right here, but the points that I want to point out for you start about here. She will not engage directly, that part's always fine, or indirectly, in any manner whatsoever. Then there's a bunch of examples. Owner, principal, those are pretty concrete. What about agent? That's a pretty broad term. I think even contractors can sometimes be agents of an organization or representative. And then we have this, or in any other similar capacity in one of these things, establishment, management, or conduct. So that's where it starts to open out. That's where it starts to become broader and may cause us problems. So now let's turn to the real meat of this. What does it mean to be functionally reasonable or functionally not overbroad? This is hard because the courts have discussed this requirement in different ways, as you've noticed. But I would boil it down to these 3 questions that we might ask for functional reasonableness. First, does it prohibit only direct competition? Think about the language in Omniplex, where all it focused on was, are you only prohibiting direct competitors or working for a direct competitor? Second, does it prohibit more than what the employer actually does? Look at both the Home Paramount case and Capital One Finance Corporation. They have good language about what that means. Third, does the non-compete prohibit the former employee from working for a competitor in any capacity? And that comes also from Home Paramount and Omniplex. All right, so let's try to figure out what this really means in practice. It is hard in the abstract. So let's do a hypothetical. Say that Leslie Rhodes has quit this job and now she wants to be a freelance writer who does web content writing for a lot of different companies. One of her companies is a client that does similar work to co-works, and they're also in Central Virginia. And her job as the freelance writer is to write, blog articles and write promotional information about how great that co-work company is. Is she then prohibited from the non-compete from doing this? Well, let's look at the non-compete language itself. I don't think directly would be a problem, but maybe indirectly. What does that mean? That's pretty broad. Is she an agent because she is a contractor writing material directly for another organization? Or, whatever in any other similar capacity may mean, is she doing that? And again, it has to be tied to the establishment, management, or conduct of a co-work facility. Now, I think establishment is not going to be a problem here. Establishment really tends to mean the creation, the founding of an organization, which she certainly was not in this hypothetical. Management would be leading up the organization, which he does not do in this hypo. Conduct, that's a closer call. I think she could be potentially involved in the conduct of it by helping with the website copy, but maybe that's a stretch. Regardless, if you think the answer is that she is prohibited, how would you analyze it? So one way to do that would be to look at the exact rationale and language from these other cases. So looking at Omniplex, here's the main quote where the court explained why it was overbroad. And there they had an example of a vendor. Even the vendor work would be prohibited for her. So is it more like this Omniplex restriction in our case? I would also look at the other case where the court found the non-compete to be unenforceable. In Home Paramount, this is what the court said there, that it prohibits Schaefer from working for Connors or any other business in the pest control industry in any capacity, which they think is overbroad. It bars him from engaging even indirectly or concerning himself in any manner whatsoever in the pest control business, even as a passive stockholder. So now you have two examples where the non-competes would prohibit working as a vendor or working as a passive stockholder. So is our non-compete closer to those, or is it closer to the clauses which have allowed everything except for direct competition in those three other cases? All right, so at this point, you may be thinking, there's a lot that is unclear. And you're right to think that. I've deliberately made this case study similar to what you'd really encounter in legal practice, which means that there's often not one clear standard. There's not often one clear answer about how the contract will be viewed. But remember, our job is to be clear about what is unclear. So how do you address that in your actual draft? One thing that may be difficult to get around is to think about how to be clear that it's not clear. So it's fine to say the courts have interpreted this rule in different ways. In fact, I think you should say something like that in order to be upfront and to advise your partner as well as possible. Similarly, you might say something like this. In the Home Paramount case, for example, the court placed greater emphasis on the functions of the employee. And maybe you'd say, in the other case, the court focused on the employer's functions more in order to determine functional overbreadth. And so these are just examples of how you could handle that question and be clear that there is a variety of opinion about approaching this. All right, now with that in mind, how should we structure this memo? I think there are two basic ways you can do that, though there probably are other ones that would work just fine. You just need to try it and see what feels the best for you. So the first way would be looking at cases and trying to group them by thinking of which cases upheld the non-compete and which cases struck them down. So there are two cases, Home Paramount and Omniplex, where the court said the non-compete was unenforceable. Then there are three cases where the court said the non-compete was fine. So could you structure your memo so that you talk about these two cases on the one hand, these three cases on the other hand? And if you did that, you'd want to be clear, is our case more like or less like one of these cases? Or maybe there's a little bit of both, Maybe one is clearly not like ours, but one is mixed. So these are just examples of how you might think about it. I'm not necessarily saying that two of the cases are exactly like this. Okay, so that's one way of handling the structure of the memo. Another way would be to think, about cases that are similar to ours and cases that are different from ours. So let's say that all these check marks are cases that are similar to ours. So there's two cases that feel really similar, one case that's kind of mixed, and maybe two cases that are very different. Again, this is just my example. If you handled it that way, I think you would start out with cases that are the most similar to ours, and then move down and explain why the cases that are different are different. So I think either way could approach this fine, and it's about finding the way that allows you to write the most effectively. And regardless, what you want to be clear about is some kind of conclusion, even if the conclusion is that the law is not clear. Because ultimately, we know that the legal decision that your partner needs to make is just this: how should I advise my client?